This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why COVID strikes again and the New York governor, not being a national or international body, requires Chubb to pay for the cancellation of a Tina Turner concert because it was canceled only because of the order of the state of New York and the city of New York. In Tina Turner Musical LLC versus Chubb Insurance Company of York SE, a December 6, 2022 decision of the Supreme Court of New York First Department, an appeal from an order of the Supreme Court, the trial court, of New York County, Andrew Borrok, Justice, entered on or about December 30, 2021, that denied the defendant's motion to dismiss the complaint. The New York Appellate Court unanimously affirmed the decision of the trial court. New York appellate courts are noted for the brevity of their opinions, and this one is no exception. The appellate court concluded that the trial court, the Supreme Court of New York County, correctly concluded that plaintiff's losses resulting from the cancellation of its Broadway show during the COVID-19 pandemic did not fall within the communicable disease exclusion in the insurance policy. That exclusion precluded from coverage, quote, any loss, directly or indirectly arising out of, contributed to by, or resulting from any communicable disease or threat or fear of a communicable disease which leads to 1. The imposition of quarantine or restriction in movement of people or animals by any national or international body or agency, 2. Any travel advisory or warning being issued by a national or international body or agency. The appellate court noted that the exclusion did not clearly and unmistakably preclude coverage of losses caused by communicable diseases that were of such a systemic nature as to lead to quarantine or travel advisories orders by a national or international body or agency. Rather, the court said, giving the exclusion a strict and narrow construction and resolving any ambiguities against the defendant, the appellate court found that it precluded from coverage losses resulting from quarantine or travel advisory orders issued by a national or international body or agency in response to a communicable disease. Since plaintiff's losses stem from executive orders issued by the New York State Governor and the New York City Mayor, banning performances and gatherings in theaters, the exclusion did not apply. In my opinion, whenever there is an issue of whether an insurance policy must provide coverage to an insured, it is necessary to read the full policy. The New York Appellate Court did just that, as did the New York Trial Court. It read the exclusion relied upon by Chubb to refuse coverage to Ms. Turner and found that her losses resulted from executive orders issued by the governor of New York State and the mayor of New York City. Since the exclusion only excluded orders of a national or international body or agency, and since neither the governor nor the mayor were national or international bodies or agencies, the exclusion did not apply. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. And if you found this interesting, please subscribe to the blog so that you can learn about it, at least 5 blog postings a day. This will also be a video on rumble.com and youtube.com, and you should subscribe to them. And if you watch the video on rumble.com, please click on the Rumble button, and if you watched it on YouTube, please click on the like button and subscribe to one or the other videos. You might also find interesting and useful to you subscriptions to my Locals channel and my Substack publications. Thank you for your attention.